We are back with another episode of the Elders Insight, but you'll notice we are now back with a new front. We are now in full video for our podcasts. The change is big for us, and we hope you like getting to know us and our guests a little bit better this way. So my name is Gary Hepworth, and I'm your host for this podcast here on the Elders Insight, and today we're live from Toronto, Canada. As always, we continue to thank you all for your positive responses that we're getting, and we thank you for email questions, thoughts, and thumbs up. So keep them coming. Obviously, we're providing good information and we love doing it. Please continue to stay tuned for more episodes, the Elders Insight at our website, hepworth.ca, where this episode and our prior ones are easily available in our online library and only a click away. And we know not everyone can make it out to our various seminars, presentations, and workshops. That's why we began this podcast series, so people from outside of the Toronto area can view us. So a hearty hello to wherever you might be today. So let's get on with today's episode, which is entitled, The State of Your Estates. And I'm particularly excited about this subject as it's one that our clients ask about all the time, especially when it comes to dealing with things like wills, powers of attorney, and family. Yes, family. And I continue to be surprised by the statistics that tell us 51% of us still do not have a will. And secondly, approximately 70% of Canadians do not have a signed power of attorney in place. And what amazes me even further is that even those who have these documents in place, they haven't not communicated the existence of these documents with the people named in the documents, including the executor, or the location of them. So if you've got a safety deposit box, it's important that people know how to access that safety deposit box. So said, it clearly indicates a lack of understanding of the subject, which generally results in some family confusion and some stress and rushed decisions, typically at the worst time to be dealing with it. So to talk about this entire subject of estates, who better to be joining us today than the terrific Cynthia Woods? A little about our guest. Cynthia is a seasoned lawyer practicing in the Toronto, Canada area. Since starting her practice in 1994, she's been offering legal services primarily in the area of wills and estates, real estate, and small business law. But upon obtaining her Osgood certificate in elder law in May 2015, she refocused her 20 years of experience in wills, trusts, estate administration, real estate, and collaborative law into the area of older adults. She now advises and assists in a wide range of legal matters affecting this growing segment of our population. So the bottom line is Cynthia is a passionate and respected advocate for the needs of older adults, and we are thrilled to have her here today on the Elders Insight. Cynthia, welcome to the Elders Insight.
Thanks very much, Gary. It's a pleasure to be here and to talk to all of your viewers. It's a really great idea to get important and relevant information to them. And this subject, or the subjects you were talking about today, are something that I'm very interested in, very passionate about. So thank you.
Great. So let's start out with some basics. So when we talk about estates, what exactly are we talking about? What kinds of things are included in one's estate? So when a lawyer says estate, what is a lawyer actually talking about?
Well, really what they're talking about, Gary, is I like to break it down into three sort of types of property. The first one that often is what people think about a lot and what causes a lot of family angst is your personal property, which is your stuff, your jewelry, your artwork, your cars, your anything that you have in your home, your clothing, all that stuff. And it seems to have a lot of value for some people, which is mostly, I think, sentimental value in most cases. And it's one of the things that can cause the most grief in families if it's not dealt with properly. The second one is real property, and real property is land and houses such as homes that you live in or homes that you own to rent out, cottage property or business property. And the thing about this real property is that it can attach to a lot of tax if it's not properly dealt with. And then the third kind of property is essentially money or financial instruments that you have, investments, bank accounts, could be insurance policies, it could be pension, all kinds of things like that. Some of your property is not really yours when you die because you own it jointly with someone else. And a lot of husbands and wives own their matrimonial home as joint tenants. And on the death of the first to die, it becomes the property of the second, and it's not part of the estate of the first person. Some of your property, like insurance or RIFs or TFSAs or pensions, has something called a beneficiary designation. And in that case, that property doesn't go into your estate covered by your will, but it goes directly to that person or persons, whoever you set out. One thing that's come up, important kind of property to think about, is your intellectual property, which for some people is their online property.
Mm.
And often that's secured with passwords and all kinds of things that no one else knows. So it's something that's becoming more and more important to deal with in estates.
Okay, okay, yeah, that's a new one. But when you think about estates too, people always think about probate and what goes into probate. Isn't there a new term for probate now? Has the law been changed?
It's now called getting a certificate of appointment of estate trustee, either with a will or without a will. And because it's such a mouthful, most lawyers still call it probate. But essentially, there's a new scheme in place for collecting the probate fees, which is called estate administration tax. And it's a little bit more onerous for executors. And
Okay. So in the old days, people thought being asked to be an executor, was being very helpful to someone. Is being an executor now more, you said, more onerous? Is it something that people need to study more before they maybe agree to become an executor?
well, it's a big task. It needs someone who understands that it takes time. It can't be accomplished in a very short time. And there's all kinds of filing requirements that didn't exist a few years now. If they don't file things on time, and if they don't provide proper information, and they don't have proper records to back up what they're reporting. So the government's trying to collect more money than they thought they were getting before in terms of what really should be paid on estates.
Okay. So when it comes to estate planning, what kind of documents should be prepared or required? We've talked about wills and powers of attorney, those and others. Can you talk about that?
Well, when you are going to do your estate planning, you need to collect all of the documents that are relevant for your lawyer to have a look at when you go to see a lawyer about getting an estate plan in place. You're going to have some ID. Picture ID is important now for the Law Society in Ontario requires that lawyers ascertain their clients. So if you're a person without ID, there is a government photo ID process that you can undertake. And I tell people that they should do that if they don't have a passport or a driver's license.
Mm-hmm.
If you have any ties to the United States in terms of your parents' citizenship or having lived there for a while, it's important to let your lawyer know that and provide any documentation about that, because that can have an effect on your estate. It's important to have documents about the property that you own, because there are estate planning opportunities for some kinds of real property in Ontario that people have owned for a long time, and you can make it part of a second will that's not part of the will. It has to be gone through probate. So that can save you quite a bit of money. If you have any collectible debts, like a private mortgage, or you've made a loan to anyone and they need to be part of your estate, you need to have that kind of documentation for the lawyer. If you've made any contracts for funeral arrangements, you should have those available, and you should know what they're all about, because funeral instructions usually are not part of a will because they're not binding in a will, and yet they need to be available to the executor because that's the person who's responsible for that kind of arrangement. And there are just maybe other specific agreements and contracts that you've entered into during your lifetime, shareholders agreements if you own a private company, anything like that needs to be dealt with. And then you need to have, at minimum, a will, a power of attorney for personal care, and a power of attorney for management of your property.
Okay, good. So given some of the statistics we hear about people not having a will or power of attorney, you probably have all kinds of stories. Can you share some particular stories that you've had to navigate as a result? I think our listeners would benefit from hearing some real life impacts.
Well, without getting any personal details in place, which I'm not allowed to do as a lawyer, I have to keep it secret. I had a client once who was in her mid-30s, and she became quite ill and died very quickly without a will. She had a mother who lived in Toronto who was, I think she was not that old. She was mid-60s, late 60s, and she was very ill as well. She had a sister who lived in another province, and the sister was really the logical person to be the trustee, but because this woman had not made a will, her sister could not apply to be the trustee because she's not a resident of Ontario. So if you're appointed and you live out of the province, that's okay. But if you want to apply without a will, you can't do that. In this case, we were luckily able to have the mother apply to be the trustee, and the sister did all the work for the mother, so all she had to do was sign things, and we got the estate dealt with, but it could have been a problem. If you die without a will and you have a large family, there's a whole list of people who can apply to be the trustee. And what happens if more than one person thinks they should do it and they start to have fights? Because everybody who's eligible to apply has to consent. So if you have 5 or 6 siblings and 2 of them are fighting for this power to be a trustee, you can get into a lot of family squabbles that way. Who will get your estate? What happens if, for example, you live common law with someone, you've lived with them for a long time, but you own the house that you're residing in? Because a person in a common law relationship in Ontario doesn't have property rights, and that spouse has maybe lived in the house for 20 years, if you were to die, they would have no rights to stay in that house other than if they could prove some kind of a resulting trust. And they would have to move and your property would be sold and it would go to people who are entitled by statute, not the person that necessarily that you want it to go to. There may be some situations where a parent wants to not include a particular family member, a child or a sibling in a will. But if you don't have the will, it just goes according to statute, which means that everybody gets their share. And so you don't really have a chance to be selective and make your wishes known. And probably the biggest horror story is if you don't have a power of attorney, because it's such an easy document to create. And if you don't have it, someone who wants to take care of your property will have to file this big application with the public guardian and trustee. They may have to post a bond. They may have to do a report every year to them and do all kinds of things that you really don't want them to do. So it's really not fair to the people you leave behind or your loved ones to not take care of your business.
Okay. So the media likes to feature abuse, and especially around money, because there's been all kinds of stories in the media about powers of attorney being abused and people taking people's money. So what could people do to make sure that there's controls? I don't know, is there a way to put controls in the power of attorney to make sure that someone's not going to abscond with everything you own?
Well, Gary, the difficulty is that often these things are not policed because they're private and there's no one to be the police. Mm-hmm. So that let's say there's 1 or 2 children and they both agree that they're going to get the estate when the parent dies. So why should they spend a lot of money putting them in an expensive place for care when they can put them in a cheaper place? And there's no one to check that. So there has been some moves lately to have people appoint an overseer to whom the attorneys would have to report on an annual basis or a biannually or on a regular basis to make sure that they're doing the right thing. Okay. Other than that, just making sure that you have the right person for each job, because it might be important to have someone who's got empathy and personal skills to be your personal care power of attorney, whereas someone who's going to take care of your finances could be a much more business-minded person. And if you had 2 people, it could be a check and a balance. Whereas if you make the same person, both attorneys, you can run into more problems.
So one question I get asked all the time, and this plays right into your court, is should I use a lawyer to do my will and powers of attorney? Can I do it myself? Why should I use a lawyer?
You can absolutely do it yourself. You can do anything from what's called a holograph will, and that is a handwritten will that you write and that you sign and date, and it's not witnessed, and someone can administrate your estate from that, all the way up to a very expensive estate plan, which might involve 3 or 4 wills and different kinds of powers of attorney and a family trust and all kinds of things. So your estate is really, it can be serviced by a Volkswagen or a Cadillac. The problem is if you don't get the right plan for your estate, something can be missed. So it's important that you at least talk to a lawyer, because if you have nobody like that overseeing your estate, you can cause all kinds of problems. One thing that causes lots of problems is people trying to avoid probate.
Right. Okay. So I wanted to make sure we talked about a specific area that you mentioned to me the other day on recent changes in the law which have affected joint ownership of property with a parent and an adult child as an estate planning method. What are those changes and what kind of impacts will they have on us?
In 2007, there was a case called PCOR, which is a Supreme Court of Canada decision, in which it was decided that if a parent transfers property gratuitously for no payment to an adult child, then that property is still deemed to be the property of the parent, and therefore you'll have to pay probate on it. For example, a lot of parents were transferring an interest in their home to their child, thinking that on their death, the child would take it as a joint owner and blah-de-da, there'd be no probate. But in fact, the courts are not allowing that to happen. They're saying, no, unless you can prove that it was a gift to that child, then you have to pay probate on it. So there's a test on what a gift is, and there's all different kinds of documents that the courts will look at. Long story short, one of the most simple ways to sort that out is to make a second will that deals with your joint interest in either a bank account or a house or whatever you're trying to protect, and say that when you make a secondary will and you give that joint interest to that child, that it's clearly a gift.
Okay. So this is fairly recent. So this, okay. So with all the clients you've served over the years, what are some of the common misunderstandings that you come across? And what do you wish people knew more about or paid more attention to?
Well, one of these we've already touched on is that estate planning is only for the wealthy. Oh, I don't have enough estate to make it worth making a will. It doesn't matter if you have $50,000 or $500,000, $50 million. Your money has to go somewhere.
Mm-hmm.
And if you have a family, even a small amount of money can be a source of problems within the family and cause all kinds of discord and disharmony. Even in the case of a bankrupt estate, someone has to take the reins and make sure that the income tax is dealt with and all that kind of stuff. And nobody's going to apply if they are not appointed in a will when the estate is bankrupt, because there's too much liability. A second one is that people who are making healthcare decisions for you are very important people. And people think that the people handling the money are the more important people. But in fact, the person handling your healthcare decisions can impact the person handling the money. So it's really important to make sure that you appoint the proper people for each of those situations. So one more really important point is, I already touched on this, but allowing probate to drive your estate planning. Probate is not that expensive in Ontario. It's $50, sorry, the first $50,000 is $250, and after that, it's $15 a thousand. And if you plan strictly on probate, you can cause all kinds of other problems involving other kinds of tax, and it can be a real nightmare. So make sure that you make a plan and that all your advisors know about it and that you stick to it.
Can you just remind our viewers, when you sign a power of attorney for property, when does it become effective? And the same thing for personal care. When does that become effective?
Well, the power of attorney for property can be effective according to the terms of the power of attorney. Some of them say it's effective immediately and has no conditions or restrictions. I find that's more useful in the case of older adults. In the case of younger adults, it might say that it becomes, it comes into force when I'm incapable of managing my property. And you might need a trigger for that, like a doctor, an attending physician says the person can't manage their property. It could be a physical impairment or a mental impairment. It could be permanent, it could be temporary. In terms of the one for personal care, that can be a flexible situation, because one day you may be in good shape and able to make decisions about your care, and the next day you may not be. So it's really up to the doctor taking instructions to make that kind of determination.
Okay. I mentioned safety deposit box in my intro marks. Is that where people should actually keep the wills and powers of attorney? Is that a smart idea?
Powers of attorney, not so much, because if you don't have a power of attorney, unless you're a joint owner on the safety deposit box, it's hard to get into the safety deposit box. And it's my practice to make more than one power of attorney so that there are a number of originals. So if you had 3 or 4 originals, you could certainly put one in there, but I think you should keep at least one where the attorney would know where to find it. With respect to wills, I have a lot of wills that my clients have left with me for safekeeping, because that means that it won't get lost. It means that someone will know where to look when they need it, and that I won't hand it out unless the person is actually deceased, so that it can't be tampered with or disappear. I give my clients what's called a true copy of the will, and then they keep that with the original invoice And if something happened to the original will, they could prove the will from the true copy and the invoice marked paid in full.
Okay. Question about common law. Someone asked me this recently. Is a gentleman was separated from his wife for like 15 years, never got divorced, and he's been living in his view a common law relationship with another woman for the last 15 years. He dies. What's the rights of the common law wife versus the original wife, as we call her?
Well, if there's a will that leaves things to the common law wife, then she's lucky.
Mhm.
Otherwise, if there's no will, then the spouse can make a claim on the estate, as can children. The spouse, even in the case of a will for the common law, if you're not divorced and you have no separation agreement in place, the spouse can make a claim on it. I think it's up to the first $200,000 of your estate. So it's important to tie down those details of past marriages and at least have a separation agreement.
Okay, good to know. Well, Cynthia, this has been a fascinating chat indeed. Big thanks to you on behalf of our listeners and yours truly. As you know, our advice to our clients and listeners is about planning and the peace of mind that comes from it. So it's good to hear from someone else who understands the importance of that message, especially from someone with your experience with the real issues.
I'd just like to say one thing in closing, Gary, that I think people also need to think about their estate planning, not just being about them, but being about their family. And that if you plan your estate and explain things to your family before you go, you can cause a lot more harmonious relationships to develop after you go than if you make your will a surprise, cut people out, and treat people unequally. You can do whatever you want with your property, but it's best if you try and preserve family harmony by letting people know what's going on.
And it's amazing how many people just are never comfortable having those conversations, but they're important ones to have.
Yeah.
Great.
So thank you very much for having me. I've really enjoyed speaking with you, and I look forward to another opportunity to engage with your audience.
Super. Well, folks, that's a wrap for today's video cast, and we thank you all for joining us. I also want to thank everyone that have clicking in for our podcast over the prior weeks. And for another big particular thanks to our guest, Cynthia Woods, for taking the time out of her busy schedule to be with us today. I know she has lots of knowledge. So your comments have been very encouraging, and we thank you for your many great ideas for future video casts. So stay tuned for more video and podcasts as we continue to provide you with insights for seniors, pre-seniors, and their families for aging well. And tell your friends, coworkers, and relatives and neighbors that anyone else that you think that would love our show, because we've got lots of room for them here. So see you again next time.